So, a very good evening and a very warm welcome to everyone. We welcome you once again to Vestralex free online community classes on law. This is a free legal literacy initiative by you, for you, and possible only through the generous contribution of our guides, mentors, seniors. And today we have the good fortune and occasion of learning the very important topic of how exactly to establish yourself in civil law practice with the one and only Shri Prakash Ellanty sir. Sir has been to anyone who's been following this initiative knows that we've always had the kind guidance and blessings of sir. But briefly, before handing over the class to sir, I'll just give a brief introduction for sir. Sir is a senior advocate practicing at the Madras High Court. He's a first generation lawyer. His core practice areas are banking laws, business laws, corporate laws. He's a civil practitioner, started his practice in 1992. He joined the Supreme Court of India. He started practicing over there after 10 years of his practice. He enjoys living an active life and participates in various sports events. He is a member of the AG's 11 cricket team. So, sir, with folded arms, we very warmly welcome you and we request you to kindly sir, guide us and enlighten us with respect to this wonderful topic.
Thank you very much for the sweet words. A very warm welcome and good evening to all of you. It has been always a pleasure to be amongst people who are looking for more of learning. And every such occasion when it comes up, I also get to learn a lot of things. I don't look it as a session which has to be only shared. I look it as a session which gives me an opportunity of more learning. So in that context, it had been always pleasurable to be amongst the galaxy of people who are looking at more of learning, more into community learning on the legal aspects. Thanks very much for this opportunity to be part of all of you for this wonderful Sunday evening. We are going to look at the opportunities in civil law. It's a kind of a thought process as well as a discussion which I am trying to put it across to you. When we speak about civil law, the genesis goes to the common law remedies. Common law remedies have been recognized as remedies which flows out of any right a person holds. Any right should result in a case of a remedy if it is required. It may be a right to a property, it may be a right to certain privileges, certain inheritance, it may be right to arising out of certain contractual obligations. So anything which is infringed upon, these rights which are inherent or which flows out of certain obligations, which flows out of certain contracts between the parties, which at times flow out of certain statutory provisions, if these are being infringed upon and if there is anything which you have to establish such a right, you seek for a remedy, which is a legal remedy within the framework of justice delivery system. And for seeking such a legal remedy, which is in the nature of a civil remedy, you don't require any provision which has to enable you to seek for such relief. You are all aware that the Civil Procedure Code lays down the guidelines, lays down the process as to procedural aspects as to any kind of civil suit. Now, Section 9 of the CPC specifically recognizes and says that to seek for a remedy or to bring about a civil suit or a proceedings of civil nature, there is nothing which requires an authority of law. Only thing which is required to be looked into, it should not be barred in any law. So this position in terms of Section 9 of the CPC makes it very clear that any person is entitled to knock the doors of the courts seeking for a relief in respect of any right which he possesses. Now, from this prospect of the civil remedies or civil law flows various aspects from that. As I said, what was initially recognized as common law remedies has taken shapes into different kinds of it. So in today's session, what we will look at is that when we speak about civil law, as I said, the starting point would be discussing about a civil suit. Now, from there, insofar as the civil suits are concerned, how the framework of this law or framework of this field has developed over the period of time would be of some importance. Then how it is being looked upon as on date in terms of various statutory amendments or various enactments which come into place, and how this civil law has taken shape in bringing about various special statutes would be one of our final concern which we look at. Now, while we discuss and seek to look through all these things, the underlying factor is that as a legal practitioner, as a lawyer, we seek for the opportunities which arise in the field. So effectively, what we are looking at is that how does this open up an opportunities for any practitioner, legal practitioner? Now, as I said at the first instance, I will just point out to the very basis when I spoke about Section 9 of Civil Procedure Code. I will read that section as well as take you to one of the earliest judgments of the Supreme Court. In fact, this common law remedy emanates from the English courts, and you have the judgments from 1700s, which recognizes a person's right to seek for a remedy before a court of law. Now, Section 9 of CPC says, the courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. Now, what is interesting is this Procedure Code of 1908 sets out two explanations. It may be a bit of outdated explanations, but still carries the relevance in the context of how the civil law has been taking shape. Explanation 1 says, a suit in which the right to property or to an office is contested is a suit of a civil nature, notwithstanding that such right may depend entirely on the decision of questions as to religious rites or ceremonies. So anything which flows out of religious rites or ceremonies, if there is a right to a property or an office, and if it is contested, it is also said to be a suit of a civil nature. Now, explanation 2 says, for the purposes of this section, it is immaterial whether or not any fees are attached to the office referred to in explanation 1, or whether or not such office is attached to a particular place. Now, this explanation 2 came by way of an amendment inserted in 1977. So, this is the basis which I pointed out when we speak about civil practice or civil suits. Now, how this has been looked into by the Honorable Supreme Court, I just point out to two judgments. One is the case of Srimati Gangabai versus Vijay Kumar and others, reported in 1974, 3 SCR, page 882. The following is the observation of the Honorable Supreme Court in this judgment. There is an inherent right in every person to bring suit of a civil nature unless the suit is barred by statute. One may, at one's peril, bring a suit of one's choice. Please look at these beautiful words. One may, at one's peril, bring a suit of one choice. It is no answer to suit, howsoever frivolous the claim, that the law confers no such right to sue. A suit for its maintainability requires no authority of law, and it is enough that no statute bars the suit. Now, this was followed by a subsequent judgment in a context of how a right of a plaintiff has to be looked into. This is the judgment of Dhanalal versus Kalavati Bai and others, reported in 2002, Supplementary 1 SCR, page 19. Now, there, the following is the paragraph of the Supreme Court in this judgment. Plaintiff is dominus litis, that is, master of or having dominion over the case. He is the person who has carriage and control of an action. In case of conflict of jurisdiction, the choice ought to lie with the plaintiff to choose the forum best suited to him, unless there be a rule of law excluding access to a forum of plaintiff's choice or permitting recourse to a forum will be opposed to public policy or will be an abuse of process of law. Now, having said this, what essentially we need to keep in mind is that the latest various new law legislations which have come in, which had looked into creating frameworks for various disputes which primarily are civil in nature, have in fact created as on date exclusive tribunals or forums or adjudicating bodies to address those issues. So therefore, today there are statutes which exclude the jurisdiction of civil court and vest such jurisdiction in particular tribunals or adjudicating authorities or judicial or quasi-judicial bodies, setting forth as to what is the scope of jurisdiction also. Every one of these legislation would also set out what is the jurisdiction of the particular body created under that particular statute. Now, having said that, what is the broad spectrum of legal matters in a civil law? Essentially, if you look at all this emanates from disputes relating to property. The first and foremost, the dispute adjudicated was only relating to the property disputes. Property disputes may be on the ownership, or maybe on the possessory rights, maybe on the inheritance which flows through, or maybe related to property often necessitated by expertise. And these require a navigation of complex legal issues. Now then, what are the other areas of disputes which are essentially civil in nature? Are disputes which arise out of contractual obligations, persons who enter into specific contracts, delineating certain rights arising out of the contracts, and that gives rise to disputes, and such disputes may require a resolution. Now then you have disputes arising out of family law. You have a wide range of family law disputes which had been there for time immemorial. And then you have disputes which result or which require a remedy in the nature of tortious liability being fastened on the other person. So which falls in the category of law of torts. Then you have the common disputes arising out of debt recovery. Then the modern law, which you have seen, which is followed from the torts, are cases arising under the consumer disputes resolutions, cases arising out of motor accident claims or other tortious liabilities which come. So these are these broad spectrum of legal matters. Now, as I said, all these, either it is contractual disputes, property disputes, debt recovery, consumer rights, family law, or torts. What comes to your mind or what would immediately strike you is that there are many areas of these specified subjects which are now being within the domain of certain statutes. For example, if you take it up, debt recovery today is no more only a civil law remedy or no more within the domain of a civil court. If a debt recovery is required by the banks or financial institutions, you have a special statute, you have a special body, and you may have to only approach them. There is a specific bar of the civil court. Then if it is a debt recovery which results into some kind of insolvency resolution situation, then you have a special statute, again a special tribunal, again special laws which flow out of it. Therefore, what is left behind as of now, if you look at a debt recovery as between purely two individuals or only within the civil domain or within the civil court's jurisdiction. All other are now governed by special statutes. Now, when, as I said, as to rights which flow, resulting in certain remedies which you can seek, and these remedies being recognized as common law remedies, I also spoke about what is the wide spectrum of different types of disputes which come about and which ultimately results in certain legal proceedings being initiated or being defended. Now, having said that, at the first instance, let us see what kind of civil proceedings which are looked to be seen. When we speak about the civil proceedings, and when I specify as to the civil suits, you have a wonderful framework. What is the major difference between a civil proceedings and criminal proceedings is that in criminal proceedings, as a lawyer, the day when you step in, there is already so many things which have happened, which are within the domain of the court or a prosecuting authority. Now, you may have to work from what is given to you, and you may have to proceed in terms of either it is a prosecution or a defense in a criminal proceedings based on whatever materials which have come on record. Now, the major difference in a civil practice is that civil practice, as a lawyer, you would be the king. You will lay down the road. You will decide as to what kind of remedy which you are going to seek, what is the framework which you are going to create, what is the pleadings which you are going to say, what is the documents which you are going to rely upon. So a civil suit, the day when it gets initiated through a lawyer, you put in a roadmap. You may look at down 20 years or 30 years, matter goes to the High Court or matter goes to the Supreme Court, and maybe a very big interesting question of law gets decided from that. But you would be the architect at the first instance. So this starts as to a client comes to you seeking for your guidance or assistance on a particular issue. Now that issue will be threadbare discussed by you. And then probably as a lawyer, you will guide the client as to what is the remedy he can seek for. Now, once you decide upon what is the remedy you are advising for the client, then you put it across as to what are all the process which are going to be taken forward. You will say as to which court you may approach, what is the relief which you will seek, and what is the consequences which will flow to the client, and what is the, in terms of whatever monetary considerations which he has to bear in mind, in terms of the timeline which is required to be there. So all those things are within your domain as a lawyer at the initiation of a civil proceedings. Now, as we had seen over the period of time, now this all starts with a kind of a notice being issued. In any civil court, you will have a pre-suit notice. You will set forth to the other party that your client has these grievances, or your client has these rights which are sought to be infringed upon. Therefore, he is seeking for a particular remedy. Now, you will therefore call upon the other party to say that, please comply with whatever demands my client is putting forth, and which may result in a situation of a win-win situation for the both parties and give a quietus to the disputes. Now, invariably, our experience will show that all these pre-suit notices, I don't know whether, if you look at the statistics, whether it is 5% or 10%, which had stopped with the pre-suit notice. 95% of these carry through to the court process. Now, after the pre-suit notice, you now work about as to approaching the court. You will make a roadmap for yourself, decide on what is the plain contents which are going to be there, and then decide on what are all the evidence which you are going to demonstrate before the court and make it part of whatever suit you are filing. Then you will get your client also ready as to further proceedings which has to be taken forward. Now, in this manner, what requires as a lawyer, as a young lawyer, to be taken note is that the nuances which starts from this stage. One error in a pre-suit notice may result in a complete deprivation of whatever relief which you are looking at. So therefore, from there starts your whatever your due diligence or whatever your expertise which you have to put into and take it forward. Now, then you decide about the pleadings, as I said, which in a civil proceedings normally results in a filing of a plaint. Now, when I say this, that as we proceed to this session, I am also going to take you to how this framework has taken various shapes today. For example, just to touch upon, today, even in a proceedings concerning a civil right, or even in a proceedings concerning certain statutory rights, a pre-suit notice is a kind of a template which the statutes provides you. More of expertise is lost. You are only required to look into that template and address as regarding what are essential. So this, when I speak about some special statutory remedies which are there, I will also take you there. Now, when we look into plaint, what effectively we will look into, we may have to look into the jurisdiction. It may be a pecuniary jurisdiction, it may be a territorial jurisdiction. Then decide upon what kind of pleadings you put. Now, each of this aspect, you can look at the provisions of Civil Procedure Code. The other day in one of the courts when I was there, I heard one of the senior most judge saying that even till date, if you read the CPC, you will feel as if you are reading certain provisions for the first time. Such is the vastness of that code, which is the guiding factor for a civil proceedings. So every aspect of it is provided for in the CPC as to how a pleadings is to be there. Order 7 speaks about it, and how reliefs can be molded, it speaks about it, and what kind of documents which you have to look about, it speaks about it. So in those areas in terms of whatever statutory provisions you carry forward. Now, there would be some certain requirements statutorily to be met with under the provisions of the code itself. For example, if you look at section 80 of CPC, a statutory mandatory pre-litigation notice in cases of proceedings being initiated against government. Then what is more important is that the cornerstone of a civil practice lies in the drafting, and an effective drafting helps in a long way as to that proceedings itself, other than helping you as a lawyer in carrying forward. Now, what you may have to look at is that the pleadings require a kind of precision and clarity. The words you put in describing the fact situations requires precision and clarity. Then you will refer to what are all the factual details as well as details which emanates from the documents which you are seeking to produce. So therefore, an essential documents, in terms of the essential documents, you will also set out the pleadings. Then you will also make a decision as to what would be your primary evidence, what would be the evidence which you will look upon from others, or what would be the evidence which will be in the nature of a secondary evidence. Now, with this, you get to the next stage of placing this plaint before a court of law. Now, here again, if you see, from our traditional way of filing a suit, filing a plaint before the registry in a civil court and getting whatever is the diary number or registration number of the suit at the first instance, and then after the scrutiny getting a suit number, we have traveled a long way today. Even this filing today has been made so easier that you will sit in your house and just sit in your system and you e-file it. So the technology has come to our aid in a manner that there are various processes which are being simplified and made it convenient for you at most of the times. Now, this filing procedure will be decided on the jurisdictional. Essentially, at the time of initiation, one important aspect which you have to look at is that any relief is required to be sought for within a period of limitation. So therefore, any civil proceedings, as you look at the provisions of CPC, you may also have to look at the provisions of Limitation Act. As young lawyers or as lawyers who come into the profession, you would have noticed one thing. These bar acts which are being sold and which are being provided to the lawyers at the bar, other than being specific statutes which are there as bar acts, you will find a kind of compendium of laws. One important thing which you will see is that always Civil Procedure Code, Limitation Act and Evidence Act will come together. You will have one book because essentially this travels together in many ways. So therefore, when a civil proceedings are being initiated, you will look at the procedures in respect of limitation to be satisfied. Now, this gets to the next stage. Once you are before the court, the other side steps in. He is going to bring about his defense. A written statement will be filed. Then takes you to the next stage of now analyzing what is the written statement, putting across to your client and making him understand that your other party, the defendant has come up with these pleas and he is defending his case, or he is trying to say that you do not have this right and you are not entitled for this relief on these facts. Now, that will be put across, so which will come to a stage of where the court may have to look at framing issues for the suit to travel further. So that once an issue is filed, where again as a lawyer you have a role to play, you can always urge upon the court by filing a draft issues and insisting the court that these may be the subjective issues which can be taken into consideration. Likewise, once an issue is framed and the suit proceeds for trial, you are within your right at all times to seek for recasting of an issue. And as you know, the provisions of CPC also says the court has a right, even at the time of rendering a judgment, to raise certain additional issues, basis of what the pleadings and evidence is already been let in, and address that and render a finding in terms of that issue. Now, this takes us to the trial process which is there. Now, trial is the backbone of any civil proceedings. The trial is so essential that you may have to make out your case as a last resort in satisfying the court and putting across all the facts which you require to be established before the court. Now, in a trial, you have your witness to be arrayed before the court. You will have to require to take the chief evidence of your witness, which is now being substituted by filing a proof affidavit. If you look at that of late, we have been using this technology again to some advantage, where if you see many cases where proof affidavits are filed before the court, what we do is that you just adopt the plain, use the cut and paste technology, make some changes, and make it as a statement of a party by filing an affidavit. So that requires a consideration. Many cases, what you see is that the same plaint is being repeated as a proof affidavit or as your chief evidence through your witness. But what you will miss out is that what is being brought about by the defendants as their case, you would not have addressed this. So therefore, this proof affidavit being filed in lieu of a chief examination of your witness is not as simple of just reproducing your plaint evidence. It requires a consideration as to the travel of the suit from the time of your inception to the time of the framing of issues, and thereafter when it is coming up for the trial. So all those facts are required to be captured and made it to the court as your chief examination, which effectively takes to the cross-examination of your witness. And similarly, the defendant steps into the box, he brings in his witness and he produces his chief examination. Then you have that opportunity of cross-examining your witness. One thing which I need to just point out is that this art of examination of witness is slowly somewhere getting lost. I, in fact, hear some judges or senior lawyers saying that is today being dead letter. But I would not say so, because dehors whatever it is, till date, we are still on a basis that an evidence is required before the court, whether it is by examination of parties, oral examination, or documentary evidence, be it whatever, even in cases of special statutes, special forums, still evidence matters, the trial matters. It may not be the witnesses who step into the box. It may require an advocate to demonstrate to the court that insofar as whatever I have contended, this is the evidence which I am demonstrating before the court, or I am arraying before the court for the court's consideration. So therefore, it may be a position that the importance is lost, but still the significance is never, ever lost. So that portion of the trial, or that portion of examination of witnesses, or demonstrating your evidence before the court, be it documentary or whatever it is, very, very essential. You have to skillfully train yourself and skillfully exhibit the training to the satisfaction of the court to get over the situation of whatever the other side is putting across. So there would lie the very deciding factor. In one statement or in one proposition which you put across to the court, the entire ambit of the case may get a turning point. So therefore, that aspect in a civil proceedings as to the trial examination of witness is very, very essential. As a lawyer, you have a very big role to play insofar as demonstrating your case, either by way of oral evidence or documentary evidence, and so on. Then comes one more stage as to the arguments which you place. The arguments essentially required to address in terms of what are all the issues which are framed. When you are approaching a court in establishing your case, you need to make a travel as to what had happened all these times. And in terms of that, what is the issue which the court is seeking to address? Then invite the court to render a finding on that particular issue. It may be an issue which is framed, or it may be an issue in consideration in a particular proceedings. Point out to that this is what you are required to answer. And in support of that, you point out, these are my points, these are my documents. This is the basis on which I am seeking to convince this court that I have a case seeking for a relief. So you have to demonstrate that by way of an argument. Now, in cases, you may also have a situation of putting across to the court a proposition of law which is decided, or informing the court that this particular case involves or gets into a very new proposition to be explored. So examine and keep at all times thinking as to what new avenues are coming up or what new opportunities are coming up, so that you can use the maximum of this before the court and take it forward. So therefore, this witness handling, evidence which you marshal before the court, documents which you place before the court, and finally make the court to address upon or render a finding on particular issues, and thereby drive to the point that this is the relief which I am seeking for, and in support of which I have demonstrated all these things. Now, when I said all these things, what is required for your consideration would be that depending on the case, in any case, in any civil proceedings, you are going to have some underlying access to the provisions of Civil Procedure Code. Now, let me take the instances of where special statutes have come. There are statutes which says that provisions of CPC will not apply, but principles underlying the provisions of CPC will still apply. And courts have reiterated that these are all the very, very basis of a public policy in this country. So therefore, provisions of CPC, provisions of Evidence Act are underlying features in any civil proceedings. Now, this takes us to, in terms of whatever is the dispute which you are handling. It may be the Transfer of Property Act, it may be the Contracts Act, it may be any other specific statutes on the basis of which you are seeking. It may be a rent control relief, it may be any other special enactment. So all these things are areas which gives you the insight as to how you have to make yourself and carry forward in getting the relief. Now, having said this, one very, very basic outline of a civil proceedings is what I have given to you. Now, as I have earlier said, now this civil practice of seeking relief before a civil court has taken different shapes over the periods of time. This is primarily because of the various special statutes which have come. Now, on the provisions of CPC itself or on the provisions of a civil court itself, as you are aware, you have a deviation which has stepped in. Now, all these things are coming in the context of huge delays which the courts have realized in disposal of a civil matter. So at least for last 20, 30 years, this had been a hue and cry that any civil proceedings is taking a longer time in the court. Therefore, a person who institutes a civil proceedings is at many a times not able to realize the fruits of such proceedings being initiated. So therefore, there had been always a trust. And that trust brought about various amendments, changes, as you are aware, the 2002 amendments to CPC, which went for a challenge before the Supreme Court, and Supreme Court insisted that at least timelines to be followed. So therefore, from the earlier regime of where in a civil suit, people used to take even 2 years, 3 years for filing a written statement, now you have come to a stage of mandatorily looking at all these timelines being met. As I said, when an institution of the suit, a requirement of limitation is to be seen and to be established, once the suit starts proceeding, any civil court will look at the timelines to be followed. Today, for a filing of a written statement, the Supreme Court says that mandatorily you have to do it within that period as stipulated under the code from the date of service of the summons. Now, if there is going to be some extension of time by the court, Supreme Court again insists that such extension can be only for reasons to be recorded. So this is how the travel is there, or this is how the march of law is there over the period of time. This primarily brings in a lot of challenges as to lawyers, challenges in terms of what you need to address, thinking forward of all these things. Now, then you have the Commercial Courts Act, which stepped in. Now, Commercial Courts Act wanted to create a class of the civil litigations into a niche area of only commercial matters which are being taken into consideration. Now, this Commercial Courts Act made changes to the provisions of CPC. So, amendments to the CPC have been made as guiding factor for the commercial courts to function in a particular manner. So, what is provided under the Commercial Courts Act will apply to the commercial courts proceedings. In addition to that, amended provisions of CPC will also have an application. So, this is how the entire march of law is happening. Now, this brings in kind of challenges as a lawyer which you can look at. At the first instance, the challenges which a lawyer has to take it on his shoulder is that today, many a cases you require a kind of a client counseling to happen. You may even have to advise them on going forward in a proceedings. Then you may have to advise them. Days are gone where you cannot be with the belief that I have come to the court, it is going to take years. If it is going to be in favor of your client, you may still say that you have the framework such that your proceedings can see the end within a particular time frame. And if you are on the other side as a defendant, you can even advise them saying that you cannot look at a longer prolonging of this litigation. It will come to a point where the suit will get decided and you may have to work out. Now, this will take you to the next stage of case strategy to be worked out with the client, case strategy to be framed for your own self as to how this litigation has to be taken forward. Now, having said this, the very factor that huge pendency of cases causing huge delays are there resulted in a kind of a parallel system being developed. I will not call it parallel system. The exact term which is being used is alternate dispute resolution, which is ADR. Now, mandatorily, CPC had brought in mediation to be explored. Arbitration and Conciliation Act had stepped in, where even statutes are now today providing for arbitration to be explored. Then, as you know, lately the Mediation Act which has come in. So, over these years, there is a very robust system of conciliation and mediation happening in all civil matters. There is a robust system of alternate dispute resolutions happening by seeking for arbitration of disputes, by seeking for conciliation, and lately, which we seek for in terms of mediations. So these are all the new laws which have developed, which has a bearing insofar as the civil practice is concerned. So when we look at opportunities today, you can find there are persons who are specializing themselves only in mediation. There are mediation courses being conducted for lawyers, and you are being certified as mediators, and you have that opportunity of building up a career as an effective mediator. Now, then you have effective, robust system of arbitrations happening, and you must be aware that the Arbitration Conciliation Act was amended, providing in arbitral institutions into place, providing in a regulatory body in the nature of arbitration council coming up. So, though these amendments have come into force, these have not yet been notified. So, therefore, there will be a time when this will come into effectively, and that will carry the entire process which takes forward. So, client counseling, the case strategies, options of settlements which are there, or options of dispute resolution in an alternate way, other than finally getting a decree or other thing before the civil thing. Now, as a counsel, as an advocate, when you are handling all these things, what is required is that you may have to work out the nuances. You may have to shape yourself in terms of advocacy, in terms of ethics which have to be followed in the courtrooms. So these are all things. When I say all these things, the essential requirement would be how you equip yourself, how you get into these new law legislations. Now, having said this, now let me go to the next area. I will only point out as to what are all the special legislations which have stepped in, which create a kind of a bar in civil. At the first instance, I pointed out to Section 9, which said that unless there is a bar, any person is entitled for any civil remedy. Now, where the bars have started, I'll just point out the statutes alone. Take the case of Industrial Dispute Act 1947. Once this act came into force and tribunal and an industrial dispute resolution mechanism was framed under the statute, the jurisdiction of civil courts were excluded insofar as relating to industrial matters under Section 10 of this act. Then, as I said, Arbitration and Conciliation Act, you are well aware that once there is a provision for arbitration in any contract or parties agree for an arbitration, the jurisdiction of a civil court is excluded. And Section 8 specifically provides that any matter, if it is brought before the court, you are bound to inform the court that there is an arbitration as far as this dispute between the parties is concerned. Therefore, relegate the parties to the Arbitration Act. Then you had specialized statute like Electricity Act, Armed Force Tribunal Act, Administrative Tribunal Act. These are all special statutes which created tribunals to address certain specific areas, mostly which are all on service law as far as Armed Force Tribunal and administrative tribunals are concerned. And Electricity Act has a bearing insofar as the consumer utility services are concerned. Now, Electricity Act in Section 145 specifically excluded the jurisdiction of civil courts in matters disputes related to electricity tariffs, billing, and connections. Then you have Companies Act. Companies Act also said, Section 430, civil courts are barred from entertaining cases that fall within the jurisdiction of the National Company Law Tribunal, which is the adjudicating authority under the Companies Act. Then you have Cooperative Societies Act, which created its own adjudicatory mechanism, either the Registrar of Cooperatives or the adjudicating authority under the Multi-State Cooperative Societies. Arbitration, which is recognized under the Multi-State Cooperative Societies Act. Then you have the new age law of RERA, Real Estate Regulation and Development Act. Section 79 specifically bars the civil court from hearing disputes. Then Income Tax Act, Sales Tax Act, CST Act. Then two other important things which you will find is that the DRT Act and Securitization Act. DRT Act said, insofar as recovery of banks and financial institutions, civil courts jurisdiction will be barred where the adjudication or the jurisdiction lies with the debt recovery tribunal. Likewise, SERFACI Act, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, that also provided by Section 34 exclusion of civil courts jurisdiction, where it specifically says SERFACI Act is so unique that the very enactment is for the purpose of enforcing a security interest without approaching a court. Now, therefore, what is the exclusion of jurisdiction which said is that unlike in DRT Act, it said where there is a jurisdiction for DRT, civil court will not exercise. Now, in SERFACI Act, what it said is that no court will grant an injunction or entertain any proceedings which is against the measures taken under the particular provision. Then you have Consumer Protection Act, then you have National Green Tribunal Act, all environmental disputes which have to go before the NGTs created under the National Green Tribunal Act. Now, these are all special statutes which the NGT exercises jurisdiction. What is interesting as a lawyer to note is that under the new Companies Act 2013, as well as Environmental Protection Act and Green Tribunals Act, as well as Consumer Protection Act, there is today a recognition of a kind of a class actions. Days are no more that only an aggrieved person as a person who has a locus can approach the court. Today, before NGT, for any environmental concern, any person can approach. Likewise, before the consumer forum, a person who is aggrieved can approach through a consumer body. Likewise, under the Companies Act, there are class actions which are recognized. Now, these are all new areas which are taking shape, which gives a long way of more jurisdiction insofar as civil proceedings are concerned or concerned proceedings. Now, finally, if you look at one of the new age legislation is the Insolvency and Bankruptcy Code 2016. Of late, you can look at many kind of civil disputes are now before the NCLTs being the adjudicating authorities under the Insolvency and Bankruptcy Code. From what was required to be the consideration of debt and default, which would result into the company being declared as an insolvent or the company being put through the corporate insolvency resolution process. Likewise, in cases of individual insolvency, calling for a repayment plan by the insolvent so that he can be discharged of the debt burden or going through a process of bankruptcy. Now, in this, what is essentially to be looked at today, as I was initially pointing out, this debt recovery jurisdiction, which was part of the civil court's jurisdiction, was taken away by DRT insofar as banks and financial institutions are concerned. Now, in cases as between individuals and companies, that kind of a debt recovery is now being imported into IBC proceedings, where you will find many people approaching the tribunals on the question of debt and default. And many of these cases, essentially, you will see other than the financial creditors who invoke Section 7, you will find the operational creditors who invoke Section 9 of the Insolvency and Bankruptcy Code. And then it speaks about the insolvency being commenced. But that procedure is today being utilized or is being put into place for some kind of a financial discipline taking place. Today, the moment somebody says that I am going to invoke the provisions of IBC, the debtors are ensuring that the debts are being discharged so that they will not be having to go through this process. Now, as I was delivering this, in fact, my friend Mr. Sanjay Pinto has also pointed out, even in cases of condonation of delay, there is a huge march of law. The Supreme Court judgment in Isha Bhattacharya says that there can be an outer limit for condonation of delay. Sufficient cause has now been defined. And as I pointed out, the special legislations have brought down this limitation itself and curtailed the powers in terms of Section 5 of Limitation Act. There are insolvency, for example, the Insolvency and Bankruptcy Code, it says today, if an appeal has to be filed, it can be filed only in 30 days. And additionally, what can be condoned is only 15 days. So these are all the areas which have stepped in. In fact, I also wanted to point out as to certain specializations which come about by way of the Digital Personal Data Protection Act. And interestingly, you had that session even before we started it. So this is a framework insofar as looking at opportunities. Now, when I said these various different statutes which exclude the jurisdiction of the civil courts, let me only address on 2 or 3 things. One, probably looking at the Insolvency and Bankruptcy Code. Any issue today, once a CIRP is commenced, if somebody goes before an NCLT and initiates a proceedings against a company and a CIRP has commenced, there is a moratorium in place. Section 14 of the IBC Code says that there is a moratorium. 2 things flow out of it. Now, the moment a moratorium comes in, you cannot initiate any proceedings against the company. And whatever proceedings which have been proceeding, all those things get stalled. So therefore, there is a requirement of ensuring that you are abreast with the times as against your opponent or a defendant or anybody in getting to know whether there are any proceedings, and if that is so, what is the next steps which you have to do. Now, this flows to the next area of IBC. The moment a corporate insolvency resolution is initiated against a company, all claims are required to be made only before in the CIRP process, which is before the resolution professional. If you fail to make it, what is the consequences is that IBC says once an insolvency resolution happens, that there is a resolution which steps in, or if the company goes to liquidation, all claims which have been made would be addressed only in that insolvency resolution in the manner which is provided in the code, which effectively results in a situation thereafter there will be an extinguishment of all the claims. Now, this raises a question. Suppose if a person has not made any claim in an insolvency proceedings, what happens? His claim would stand extinguished. Now, post-resolution in the IBC, you cannot even initiate any proceedings for recovery or whatever it is. It can be even a case of seeking for enforcement of an obligation under the contract. The seriousness of this was recognized by the government itself, and there was an advisory by the government to all its departments saying that whenever there is a CIRP which has been commenced, be it sales tax, GST, be it electricity dues, be it property tax, local body, they went to the extent of saying it may be certain kinds of claims which are arising under the licenses which the government grants. It may be a mining license, it may be a petroleum license, whatever it is. In all these things, the ministry's advisory to all the departments was that the moment a CIRP is commenced, please ensure that you file your claims before the resolution professional. It may be seeking for some monetary, or it may be for the purpose of establishing certain rights. Unless this is placed on record, it will not form part of whatever information memorandum which is being drawn upon, and therefore any resolution may not be effective. This is one statute which I thought as an example to point out the requirement of raising up to the situation or raising up to what is the march of law which is happening, and how diligently which we are required to follow insofar as these new age legislations are concerned. Likewise, we may have to address each of this legislation and provide reliefs or provide advices to your clients in terms of the specific statute. So therefore, the moment a client comes to you, the moment you are required to address in a matter of a civil right, in a matter of a civil proceedings to be initiated, you will at the first instance have it in mind that there is no enabling provision which is required. Every person has a right to initiate a civil proceedings. As I read that Supreme Court judgment, which they said that be it whatever, even it may be a frivolous thing, if you feel that there is a right which there is infringement, or out of the right there is a remedy which flows, you are entitled to. Now, what is the first parameter which have to be looked that is there a bar? So knowingly, if there is a bar, if you are going to approach a civil court, your entire exercise will become futile. If, for example, there is an arbitration case and you file a suit, after 6 months, you are going to face a situation that the court is going to push you to an arbitral tribunal. Now, if you find that there is a company which has gone to CARP, still your client says that I have to recover money, please initiate a civil suit. Your suit is going to be hit by Section 14 of a moratorium, and you are going to be directed to go before the resolution professional to address your claim. And if it is going to be a situation where there is an enforcement by a bank under SARFAESI, and if you have to seek for a civil remedy, you cannot. You have to advise the client that your remedy lies before the DRT, a debt recovery tribunal, where under Section 17, any person who is aggrieved of a measure can go before the tribunal. Many of these legislations, if you look at, when I speak about IBC also, the appeal remedy says any person aggrieved. So the very concept of parties to the litigation is getting expanded in terms of the special statutes, given the seriousness of the issue. Earlier, if it is a civil suit, an appeal will lie only from the parties. You may have exceptional circumstances where you may seek a leave of a court and file an appeal. Now, that is not the position. These new age legislations, while it is very, very stringent, it affects many persons' rights. It also looked at speeding up the entire process, and it creates a robust system of adjudicatory mechanisms. It also provides that any person who are aggrieved will have a remedy under that special statute. So therefore, there would not be a point saying that I am not even a party to the proceedings. Where is that I can go and seek for any relief? It is not the case. Likewise, as I said, the IBC also recognizes one particular provision under Section 60, subsection 5. Section 60 speaks about who can be the adjudicating authority. Section 60, subsection 5 speaks about any question of fact or law which arises in a consideration. It has to be only before the adjudicating authority, namely the NCLT. So therefore, in a civil proceedings or remedies which arises out of civil rights or contractual obligations, be it whatever, you look at, is there any special statute which is operating? If there is a special statute, you will advise that you may have to work out. Now, at the first instance, I was saying, when a civil suit is filed, there would be always a pre-suit notice. Now, how these special statutes are there? Take the case of SARFAESI Act, take the case of IBC. Likewise, you take any number of statutes, which are all special statutes. Even a notice is provided as a pro forma by way of an annexure in the rules. How a notice under Section 13(2) is required to be issued is given under the SARFAESI Act. How a demand notice is required to be given under Section 8 for initiating a proceedings under Section 9 of IBC is set out. Now, what is more interesting is that most of the special legislations, when it provides special tribunals or adjudicating bodies, they also set out as to the format in which you have to approach the court. You are today taken to a situation of no more working on a pleadings, drafting a plain, putting across facts. You may have to only work on a template. The template says, please give me an answer to question number 1, query number 1. Your answer may be a kind of a description which you have to give. But still, all these things, today's NCLT proceedings, though it has a very serious bearing on so many things, it is nothing but a format. If it is a Section 7, it is in terms of the rules. Section 9, if it is in terms of the rules, format is given. So likewise, every other statute creates that. So therefore, you may also have to look into it, create an expertise on that, work on a situation as to how you address each of the query which is raised. And each of this query which is raised will create a kind of a jurisprudence. I will only fall back for my easy convenience, because I have been always dealing with these matters, is on IBC proceedings. The format in IBC says, what is the nature of default? Now, what is the debt recoverable and date of default? Now, many people write a clear description as to how the debt arises from different loan documents or different transactions, invoices, all those things, and they give the invoice dates. At times, they may not have specified this date of default. Now, at times, what they do is that they will give a date of default basis of their invoice or other things. But when it comes to the question of the petition being considered by the tribunal, the date of default is one essential factor because that decides the limitation of 3 years in approaching the NCLT. So why I said this is that this one small aspect of a limitation from the date of default has given at least about 10 judgments in the recent past from Supreme Court. Every aspect of it had gone for a consideration. It developed a new jurisprudence. It developed whether a decree can be a date of default, whether the invoice can be a date of default, whether at the first instance when a default occurred, or is there a continuous default? If that be the case, when is the last date of default which you have to recognize? So this is how this jurisprudence is developing. Now you will again relate back to one of my earliest statement, which I said, as a lawyer, the trial is important. The demonstration before the court by way of your argument is important. You may have to put in or think about a proposition which you are going to tell the court. Now, a smart lawyer or a person who had really done his wonderful homework, these are all the cases which had created this jurisprudence of looking at a limitation arising from a date of default in an IBC. Likewise, you have every other jurisdiction. You take cases before the NGTs under the Environmental Protection Act. Every case would have been a challenge to a person in terms of bringing it within the jurisdiction of the court and inviting an order. As you have known in many of these NGT cases, one small petition results in a jurisprudence. More particularly, if an example, if I have to point out, the Environmental Protection Act provided for certain concerns to be addressed in the environment. Now, one area which came into a huge jurisprudence is the waste treatment by the local bodies. Now, all these things started with 1 or 2 petitions being filed before the NGT and taken up to the Supreme Court, where solid waste management rules came into place. Then Central Pollution Authority was directed to form a committee, address. Then pan-India, they started looking at how each of these local bodies are disposing of this waste which is being generated. Then disposable waste, non-disposable waste, medical waste. So all those things have taken a shape and have traveled with a march of law and wonderful jurisprudence is in the context of somebody's proposition being urged before a court saying that please consider this. And this is the provision of law which says that you have a jurisdiction to consider. And this is the provision of law which says that you can in fact exercise your right and issue certain directions. So with this, I think given the time constraints, I will conclude and giving an outline as to the huge, wonderful opportunities which are there for the practicing lawyers in looking at this civil law, in looking at how the civil law had taken shape over the years, and how the new age legislations are giving very many avenues in exploring yourself. Thank you very much. Thank you for this time. And it had been a wonderful experience. And I hope it is also useful for each of the participants of this session.
Sir, deepest gratitude. And sir, at the very start itself, I convey thanks from all participants and everyone who's going to watch this session in the future. So it was whatever messages and feedback I've received so far, everyone is. So this is, I think, one of the most comprehensive outlooks of civil law that has happened. I don't know, so I don't think that there is anything more. I'll just straight away want to shoot 2 questions which people have shared. I'll reserve mine for later on to you. I think Dr. T. Ramaswamy sir has something to say. Sir, please. So you will have to unmute, sir.
It was
Please,
a wonderful session. All the civil law has been brought under one umbrella. That's all. Nothing is there to be. What question is to be posed? He has himself posed question, answered also. That's all. Thank you very much. Thank you very much.
Thank you, sir. Thank
Very, very great. It's a very great.
Thank you. Thank you. Thank you.
Sir, Om Prakash, sir, on a lighter vein, sir, I just want to say one thing, sir. We were all spellbound when you started and when you concluded.
Thank you.
And that is something which everyone will say for eternity, sir, for what this session was. And I know for sure that anyone who's a young lawyer who's starting their practice at that stage, if they get the opportunity of hearing you in this particular session, how you have absolutely broken it down, sir. All of civil law. Whatever, at least whatever my ambit was, it has only grown. So I'm getting goosebumps in my beard. Like I've grown a little.
No, it is
That's
basically that anxiety of sharing certain thoughts. That's all. And as I said, every session, I may have done this from 5:10 or something, and I do not know how it go on. But last 3-4 hours, I know how much of tension I was put to this session and keeping myself. So that is a learning experience which I also look. The once that is done, I only look at sharing that experience with our friends.
it's most kind and most generous of you, sir. And so I think this is one of the best things which can happen to anyone who watches this in 2024. Now, sir, because sir, anyways, I will only keep talking to you. I think that is the one part which I enjoy the most these days of these classes. So I just request everyone that if there is anything at all, so see, only thanks, sir. So many, I have not seen like everyone how diligently you were there. Everyone is just diligently just noted their thanks in this. So just one question I think which is there from Sanjay Pinto sir only. So he says apart from the message that you read, he says that no, not the this one. Okay, there's. So I think sir everything sir you've covered, sir. Even whatever came in chat also, I think that has also been covered. So there is this one. So Sanjay Pinto sir only he says that sir, other than a counterclaim or a set off, can a reply statement to a written statement be allowed under Order 8 Rule 9?
It has to be essentially. See, on the first principles, a counterclaim is always treated as a suit by itself. And there is one latest Supreme Court judgment also which said that even if there had been an impression or a notion, once the suit goes, the counterclaim has to go. In other words, if a person who has filed the suit, if he withdraws, where does it lie? But today the Supreme Court has come out and said that this will independently stand. So a counterclaim by itself is a suit on its own. So all that which is required for a suit will also follow suit insofar as the counterclaim is concerned.
So just a small clarification. What I meant was other than because this is, I think, if I'm not mistaken, a 2002 enactment of the CPC where
Yes.
Order 8 Rule 9 was brought about. There are only two scenarios as I see it. One is if there is a counterclaim, and two, if there is a set-off. So my question is, in the absence of both a counterclaim or a set-off, can a reply statement to a written statement be allowed? Because as I understand it, the legislative intent of this amendment was to prevent pleadings from becoming a sort of an interminable rigmarole.
Correct.
But
correct.
are there cases, is there a legal basis
No,
for
today
allowing
there is no such scope, but there is one judgment which said with this specific leave of the court. In a specific case, you may have to get the leave of the court for filing a reply, satisfying the court that there is something which is new which has been brought about, therefore I have to reply. Or otherwise, today the position as far as CPC in civil suits are concerned, that is no more available.
Okay, so I think that was the election matter, sir, the election suit.
Yes. I'm not able to recollect immediately, but I have read that.
Sure, sir. Thank you, sir.
Thank you so much, Pinto ji. So there is one question from Mr. MKK. He says under section 69, would you want to, so please, Mr. KK, would you want to ask? No, I think it's a statement, more or less. Okay. So, Mr. Gupta, Dhananjay Gupta, please.
Hello, sir. Is my voice audible, sir?
Yes.
Yes, you're audible.
So, sir, my small question is with regard to the public policy in terms of Arbitration Act, sir. So,
Yes.
what does the exactly public policy mean in this is what I want to understand, sir.
Now, that act itself, by way of an amendment, they have specified what a public policy would be there. Essentially, in substance, what they are saying is that public policy means there cannot be an award which is against the well-established statutes of the country. It's only a summary I'm pointing out. They gave out in clear explanation also in 34 by way of an amendment, bringing out what public policy can be. Now, still courts have interpreted, because if it is read only in that context, it becomes very, very narrowed down. That scope of setting aside the award becomes very, very narrowed down. And we can find that no question of actual detail can be gone into in a 34 petition. It should be clearly a question of law decided, and that question of law which was decided to be picked up and shown that it is against a particular statutory provision or the policy of a particular statute which is in prevailing. So this was the area. Therefore, if you look at the march of law, and Supreme Court had got into a situation as regarding perverse appreciation of evidence to some extent, and they have gone on one basis in appreciating the evidence where they said that if there is any finding or a decision without evidence, finding or decision with no evidence is held to be against a public policy, therefore it will be interfered. So that scope is very narrow, and that scope is sought to be clearly explained in judgment. That is what is the position today.
Okay, sir. And sir, if may I one more thing, that
Yes.
when we proceed with the civil suit, so generally we try to give a legal notice to the other side. So, and if there is no reply to the legal notice, or there is no defense given by the other side through legal notice, so is that legal non-reply of the legal notice have some bearing in the trial in the civil suit?
Depending on what is the fact situation, there is a judgment of Supreme Court which said that if they have not answered, there is a situation of an admission. But it all depends. If you have specifically attributed a particular fact or a situation in a notice, other than establishing right. See, the notice can be saying that, for example, I'm saying, let us take a simple money recovery. There is a promissory note in terms of which you are bound to pay. You have not paid, therefore I'm entitled to recover. I am issuing this notice calling upon you to pay the amount of this much as principal, this much as interest. This is simple. Now, there is one more situation you will add saying that you paid up to a period of time, then you failed. Then you may say that you have in fact acknowledged. Then you may say that by a particular communication, you have in fact said that you will discharge it within 15 days, but you failed to do. Now, this aspect, if you have sent it, this will come to an extent in a trial or in the written statement. They cannot take a defense saying that I have not sent any such letter or that letter is fabricated. If a defense is to be taken, that so-called letter which you are relying is a fabricated or which is a forged document, that will be difficult for them to raise if there is no reply. So it all depends on that particular fact, where you will get him cornered to the point that his non-reply will amount to an admission.
Okay. And so, if with your permission, sir, one more thing, sir. Sir, in Commercial Court Act, there is an annexure of after pleadings, after conclusion of pleadings, in support of our plaint, we filed a statement of truth, sir.
Yes.
In statement of truth, sir, in para 6, I say that the above mentioned pleadings comprises of dash number of pages, each of which has been duly signed by me, the person who is attesting the statement of truth. So,
Yes.
sir, my question is, that what does pleading here means in terms of the documents annexed to the pleadings, that also will be counted as a part of pleadings, that has to be also be signed, or the only the statement of facts that I have pleaded in my plaint along with statement of plaint? That's
it is what is pleaded in the plaint, because they are specifically given by paragraph numbers.
Paragraph numbers. Okay, so yes, only those pages I have to sign. But the person who is attesting signing the statement of truth has to sign.
Yes.
Because I came across with a situation wherein the court said that every single page, including the documents, need to be signed. So I said that pleadings does not include the documents. It only...
There are always certain procedures which the courts evolve by itself, and they say that this has to be read into. Each court has its own kind of procedures being followed.
And that's they're very well taught by the registry to all lawyers who are trying to get the matters listed. Yes, and sir, have to cure defects. So then I hope you got your answer, but very enlightening questions actually. Thank you so much.
Please, sir.
So one question, sir. Actually, so we've taken a lot of your extra time, but sir, you've been kind enough to indulge us and consider. So I'll just ask just one question that I have at my end, and in the meanwhile, just a final shout out to everyone that if there is anything at all that you want to ask right now, please just put it in the chat or just raise your hand, so that way we can still address. Otherwise, it will be left. So, sir, one thing that I've personally had the fortune of observing at the Supreme Court is that in most of the civil appeals which are pending, there is one application which is, I see, being moved the most. That is under Order 22, Rule 3 or 4, that parties are being substituted. Someone has died, the original plaintiff and whatsoever the original person who had who were parties, both the parties are dead, and whatever matter is happening, it's just happening now. So, sir, there is this apprehension, and you told, sir, everything with respect to how new dimensions are also being added. But so, when any lawyer is approaching a matter, uh, how should is there a way of formulating a case or conducting a case in which it can a civil matter, sir, which can be effectively culminated in one person's lifetime only? Or because there is this very strong apprehension with respect to everyone that एक बार फाइल कर दो फिर उसके बाद फिर वो पीढ़ियां लड़ती रहेंगी. So with respect to this, it's very important, sir, for some faith in civil practice.
One, that the thrust which is being now made by legislations, amendments, as well as judgments on adhering to the timelines is the only thing which we can look at. But nobody can give that assurance, or nobody can even work towards that you may have to bring an end to a litigation during one person's lifetime, because that life itself is uncertain. Today you may file a case and within a month you may not be there. So that can never be assured, or that can never be even thought of as it is. But we are today looking at timelines in terms of the statute amendments as well as the judicial pronouncements. If that is taken care, to some extent this is being addressed. And there is also one thought process. In fact, in Madras High Court, there is a suggestion which has come about to work on the rules, saying that cases where legal heirs have to be brought on record, simplistic, or cases where, for example, by virtue of successions happening, a particular name gets substituted, or a company's name gets substituted by virtue of a change of name or an assignment, whatever it is. Now, all these things, instead of putting through this strenuous process of filing an affidavit, petition in support of the affidavit, and getting it scrutinized and numbered and filed it, then queries being raised, are they only the legal heirs? Do you have any document to substantiate? So this is sought to be dispensed with, at least in cases where statutory succession flows, where assignment happens, where legal heirs are not being disputed on both sides. The Madras High Court, in fact, suggested that why can't you go with a memo? You just bring it a memo on record, let the other side say no objection, you will substitute it and go ahead. So this is one thing. But in a civil proceedings, there is a consequences which flows, because with the death of a party, there is an abatement of the proceedings, which is automatic, which happens. There is no requirement, even an order to be passed. If a plaintiff had died, suit gets abated. That's all. There is an end for it. How this abatement will be removed is that by bringing the loss on record. Therefore, you have to seek for setting aside abatement and to bring the substituted parties as legal heirs on record. So that one area of civil consequences is there. So far as parties are before the court and there is a consensus, these processes can be reduced, and they can look at somewhere to make it very faster.
Absolutely. So it sounds very nice. Actually, that memo suggestion of the Madras High Court, that's actually very appreciable. These are real people, they can dispute with respect to so many other disputes. And it usually takes up at least 1 year's time to finalize who these people are. And then, sir, actually, sir, I got the opportunity of getting entangled in some such scenarios. So for the past 3-4 years, only legal heirs are being added, and the entire suit is kept at a separate place. So just one final thing at my end. You mentioned that there is so much deliberation that any young lawyer would have to do, and you showed the facets also. That even if someone comes to you and there is some money which is due, you have to check what is the status of that company, whether if it is already been filed in some CIRP has been initiated or not, whether if some other proceeding is pending or not. So what should be the due diligence that you mentioned? So just in short, what would be that due diligence that any young lawyer should do when he gets a new brief?
Yeah, today technology is helping in a big way. You have websites which have a complete data of all these things. From the earlier days where you may have to go here and there and search. Today, take it the Ministry of Company Affairs, you have got enough data on that. If it is an insolvency cases, you have IBBA's website, which records every CIRP being commenced against any company. Then in addition to that, e-courts is coming up in a big way. The e-courts reciprocity provides all details which are required. So what is required is that just looking at the system and getting into the authenticated website and get the details. Nothing more is required. You may have to create a kind of a tick box system. You will list out. Let me check at IBBA. Let me check at e-code system if there is any case. Let me check at MCA. What is the position of the company? Likewise, if it is an individual, let me check at either their personal verification, whatever it is. You just create a kind of a template, check all those things and done. And that gives you the entire material which are required to going forward.
So it's very, very kind of you. It's very generous of you, and so absolutely at your service, sir. Always, like sir. Today is one day, sir, when I feel that I really feel that whatever initiative we've done, that if through such things we can get, and if other people can also get, then possibly then all the effort and everything is worth it. So, deepest gratitude to you, sir. And so also, sir, I so also just one final thing, sir, I request on behalf of all the participants and all people who will be watching and who are aware of you, that sir, we need more such sessions, sir. On I understand now, so civil anything it also, and I request everyone also, please, yeah, just give your thoughts in the comments on whatever videos you watch. That what are the topics? If you see Om Prakash sir and you think that possibly there is something that you would want to learn from him, then either the best part is you go to him, you pay him, and you ask him. Right? That's the best thing you can do. If not, then you tell us what you want to learn from him. We'll request him. We'll take some time. We'll figure something out, and we'll definitely try to have some sort of conversation on that. But sir, most sincerest gratitude.
On date, in fact, I am out of that situation of where I can take fees and pay.
So that's yeah. You guys, yeah. Please just comment, and we can talk. We'll talk.
To do that, yeah. So
of course, I'm so sorry.
Anything, no problem. Any counsel who comes, I am always there.
Yeah. So I am there, guys. I volunteer.
When I get an opportunity, I am definitely will be there. Thank you.
And guys, I volunteer. Okay. So yeah. So I think so. This is why the entire senior situation it arose also, right? So that young guys can also keep getting some food to eat. So deepest gratitude to you, sir. So with your permission, I'll end the session now.
Thank you, sir.
Thank you. Thank you. Thank you, Baraji. Thank you.
Thank you so much, everyone. Thank you so much. And to everyone who's been with us so far, guys, please just feel free to share this video with more and most of your friends. At least I would really want to have some kind of feedback coming on the video also with respect to what you've been able to learn in this. At the same time, today is day 3 of these classes. Day 4 is tomorrow, and day 5 is day after. So we still have a lot of good learning pending with us, and everyone, all the faculty members, all the guests who've been kind to share with us their wonderful knowledge. It's just amazing. So again, tomorrow we have PS Rajgopal sir. He's going to be speaking on a very interesting and unique topic of service laws applicable to private sector employees. This, I'm certain, is going to be very beneficial for everyone. Then or day after, which is the final day so far, culmination, what we're thinking of this particular series of classes for this year will be understanding IBC practice and opportunities with VP Singh sir. He's also a former member of NCLAT. And on 24th itself, also we have another class which is with Honorable Justice Challa Kodanda Ram sir. He's been a tremendous guide and mentor to us. He has supported us through, I would say, some of the most, more challenging times that we had when we were definitely, evaluating and reevaluating the initiative. So he came as that person who helped us move forward, and along with everyone. So all these other classes are also available on YouTube. So please just watch and share with your friends. This is a free initiative. This is by you, for you, and again, possible through all of these seniors. So I request that please share it with as many people as you can. Let people know who are the real stars, the real celebrities of the country, right? Those are not the people who are selling you whatever things you watch on TV. Those are the people who are coming to your aid and to help you at the point of time when you need it the most. So our sincerest, how do I say, gratitude to all the faculty members who've been there. Today we had the DPDP Act class also. So, whatever your feedbacks are there, please just feel free to share. And with that, we'll end the class today and look forward to see you tomorrow. Goodbye.